Welcome to Books of Our Time, brought to you by the Massachusetts School of Law and seen nationwide. Today, we shall discuss, for the second installment, a book entitled Act of Congress by Robert Kaiser. The book tells a story of how Congress really works, or doesn't, and follows the journey of the financial reform bill, the Dodd-Frank Act, which was enacted in response to the great crash of 2008. The book's author, Robert Kaiser, a long-time and quite famous reporter for and editor of the Washington Post, is with me today to discuss his book. And I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. Bob, thank you for coming up.
Thank you.
You point out one of the things that one sort of inevitably is aware of without thinking about it, but you discuss it a little bit, is that the two houses are like separate fiefdoms. They have so little to do with each other. They call it the two sides of Capitol Hill, and I guess it is true. I've worked on one side very briefly, and I've dealt with the other side a little more extensively, and boy, it does seem like never the twain.
They both have this habit of referring to the other body.
The other body, yes.
They don't use the name, which is fascinating, reflection of this reality. But it's fun from a reporter's perspective. You could go back and forth, and they're contemptuous of each other. They're both absolutely convinced that theirs is the superior body, and they say so. And they're very jealous of their prerogatives. So at one point, Barney Frank was absolutely certain that he knew what Chris ought to do about a certain problem he had on the bill. And he's telling me what Chris ought to do. And I said, well, have you told him? Oh, no, he said, he would not welcome that.
He's relying on you to carry the message.
Yeah, he was, apparently, which I did not do.
Yeah. Why are they so contemptuous of each other?
Well, I think there's a certain amount of, why is Yale contemptuous of Harvard and vice versa? Well, the kids are, because they're supposed to be, because they're rivals. Yeah. That's part of it. It's a kind of juvenile rivalry. But it's interesting. From the House perspective, the Senate is a completely gummed up mechanism. It moves so slowly. Interesting statistics. Every Congress, the number of bills passed in the House exceeds by 50% or more the number of bills passed in the Senate. The House is constantly sending bills to the Senate that are buried and forgotten. Nothing ever happens. And this is a very important source of House contempt for the Senate. In the Senate, you hear the complaint, oh, the House, any way the wind blows, the House is following the wind. That just as the founders intended, right, that the House is too responsive to
that's why they have only
opinion.
2 year.
Exactly.
Yeah.
So that's the source in the other direction.
Passing this bill was no easy task. To get there, we had to overcome the furious lobbying of an array of powerful interest groups and a partisan minority determined to block change. So the members who are here today, both on the stage and in the audience, they have done a great service in devoting so much time and expertise to this effort, to looking out for the public interest and not the special interest. And I also want to thank the 3 Republican senators who put partisanship aside, judged this bill on the merits, and voted for reform. We're grateful to them.
For 25 years, the Massachusetts School of Law has been training great lawyers and building great relationships.
Joining MSL was more than just making friends. It was becoming a part of a family, which makes it very difficult to leave.
I don't want to leave MSL.
We didn't want to leave MSL ever! Best decision ever! We love MSL! We don't want to leave!
The Massachusetts School of Law. Great lawyers, better people. Come join our family. Visit us today at mslaw.edu.
I get the impression, Bob, that notwithstanding, Wall Street lobbying is extraordinarily enormous in scope today, maybe precisely because of the bailouts and the disaster, and if anything, is bigger than ever.
Well, I don't know the statistics, which are knowable, but there's a lot of money being spent on lobbying. I mean, the whole stimulus package, the bailouts, all of this has provoked more lobbying because this is what, this is the nature of the beast. And it's important to understand that too, I think. Why do people hire a lobbyist? Well, to get a benefit from Washington or to preserve a benefit that Washington has provided in the past are the two biggest reasons to hire a lobbyist. And when Washington is suddenly creating a whole new spending stream in the stimulus package and in the bailouts, then people want a piece of that. They hire somebody to help them get the piece of it. And that it does explain what's happened. Also, the banks and the Wall Street people realize, the smart ones, I think all of them by now must realize, how public opinion has turned against them. So they're looking for protection. There are two ways to get protection. The most useful probably is campaign contributions. And we see already a big uptick in that number, and it's not even an election year. We'll see more of it next year. But the other is to hire a good lobbyist who helps you make your case, make your arguments.
Just 19 months after TARP was enacted, Congress passed the Dodd-Frank Wall Street Reform and Consumer Protection Act, the most comprehensive reform of our financial regulatory system since the 1930s. Dodd-Frank contains three main elements that work together to address the too-big-to-fail problem in particular. First and most important, Dodd-Frank gives the government authority to shut down and break apart large non-bank financial firms whose imminent failure might threaten the broader system. It does so in a way that protects the economy while ensuring that large financial firms and not taxpayers bear the cost. Dodd-Frank provides us with the tools to ensure that no firm will be insulated from the consequences of its actions or protected from failure. Dodd-Frank makes clear that taxpayers must not be asked to bear the costs of a financial firm's failure. Second, Dodd-Frank creates a framework for identifying and responding to risk in the financial system. It creates the Financial Stability Oversight Council, FSOC, and the Office of Financial Research, the OFR. FSOC is charged with identifying risks to financial stability, responding to any emerging systemic threats, and promoting market discipline. OFR supports this task by addressing the critical need for more standardized, more useful, and more reliable data. Third, Dodd-Frank requires regulators to impose substantially stronger prudential standards. Risk-based capital, leverage, and liquidity standards will be tougher. Bigger and more complex firms will have to hold more capital than smaller and less complex firms. Dodd-Frank also requires that certain large firms undergo regular stress tests and requires living wills. It also restricts risky activities by banks, such as proprietary trading, as well as the excessive growth by acquisition of the very largest firms.
Massachusetts School of Law. Legal education that is practical, accessible, affordable, and enjoyable. Offering flexible day and evening classes, full or part-time studies, where candidates are assessed not on the LSAT, but their academic and other accomplishments. Providing more professional skills training than any other law school in New England. Massachusetts School of Law. Visit us at mslaw.edu. Training students to become successful lawyers and advocates, not just legal scholars.
Dodd-Frank sets a clear path forward. We have made important progress since enactment to implement its provisions, but there is a lot more work to do. The financial markets are closely watching this progress, which underscores the importance of the implementation.
It's amazing that so much money is spent on lobbying, and particularly by major industry, and it's just an infinitesimal fraction of what these companies are making. The return to lobbying must be stupendous.
This is a really interesting and important fact, which I realized writing the last book. Washington's got a perverted economy, and there's much too much money in Washington. But compared to New York, it's the minor leagues.
And when you talk about the top.
Yes. Yeah. Nothing illustrates this better than the point you're making. In Washington, if somebody comes to Washington and says, I got $100 million to spend on lobbying, wow, that's big money. And you see that in this case. The financial sector in the 110th Congress, which passed this bill, the financial sector was the biggest spender on lobbying, hundreds of millions of dollars. But as you point out, for Goldman Sachs to spend a couple $100 million, it's chump change. It's nothing. It's a huge amount of money for the lobbyists themselves, who get to spend and earn these huge fees that they make. It's a huge amount of money for the members of Congress who receive generous campaign contributions from those companies and their lobbyists and their officials. But for Goldman Sachs, it's nothing. This imbalance, I think, helps explain why this money is sloshing around in Washington. Because, as you say, the payoff, if you get a provision that can save you billions, it's worthwhile.
Frequently, clients and students and others ask me, what are my rights when I'm stopped by the police? Well, first of all, what you should do is do 3 simple things. Use your common sense, common courtesy, and stay calm, all of which are often in short supply when we're pulled over and inconvenienced. But pull to the side of the road. Whether it's day or night, you really should keep your hands on the steering wheel and the vehicle illuminated. When we reach over, as we oftentimes do, to get our registration or other things out of the glove box, the police officers see a furtive movement and become concerned for their own safety. So until the police officer comes to the vehicle, keep your hands on the steering wheel and make sure the car is sufficiently illuminated. You have an obligation when stopped by police to identify yourself. Perhaps the police officer is only pulling you over to remind you or notify you of a safety issue. Maybe you have a defective light or something. More than likely, you're right, there's some other issue involved. But you do have, whether it's justified or not, you do have an obligation to identify yourself and cooperate with the police. If the police officer chooses to go further, then at that point, you may receive a warning or a ticket, and in some unusual situations, you could even be arrested. But if you receive a warning, then there's no need to do anything further unless you choose to make a bigger issue out of it. If you receive a ticket, you can either pay the fine or you can request a hearing. But unfortunately, that hearing is not going to be the type you see on TV with the lawyer and the jury and everything else. Generally, for a citation, you have no right to have a lawyer appointed for you, and you have no right to have a jury hear those issues. The fact of the matter is, it can be a relatively simple procedure. Be prepared to discuss with the judge in a collegial fashion your problem.
When I was a kid, same time you were a kid, about 1963, 64, 65, we would hear about a woman named Brooksley Bourne, because in those days women didn't go to law school, number one, and number two, she was editor-in-chief and first in her class at the Stanford Law School. I said, holy cow, you know. And then she came to Washington, and she worked it out as a partner in Arnold and Porter, which was once was Arnold Fortis and Porter, et cetera, et cetera.
Regarding the enormous and unregulated over-the-counter derivatives market, your institutions are 4 of the largest OTC derivatives dealers in the world. The Office of the Comptroller of the Currency has reported that in September 2009, you collectively held over-the-counter derivatives positions of more than $230 trillion in notional amount. Your positions consist of more than a third of the world market in over-the-counter derivatives. Mr. Blankfein, in your written testimony, you've stated that standardized derivatives should be exchange-traded and cleared through a central clearinghouse. And you further state, quote, "This will do more to enhance price discovery and reduce systemic risk than perhaps any specific rule or regulation." I would like to ask your opinion of the role that over-the-counter derivatives played in causing or contributing to the financial crisis.
I think people may have different opinions about this, but I would say that the aspects of the over-the-counter derivative market was a very, very big concern and a big worry, so much so that a lot of institutions, all of the institutions here, I believe, were working very, very hard to make sure that the plumbing, that things would settle, that things would clear, and that we started the process of creating these clearinghouses well in advance of this particular crisis.
She warned about a lot of these things in the late 90s when she was head of a Washington regulatory agency. Why don't you tell what happened, what Greenspan did and the sainted Larry Summers did and so on and so forth?
People say, Greenspan among them, nobody saw this coming. This is a once-in-a-millennium event, this great crash. Nobody could have prevented it. It was just an act of God, in effect. That's just wrong. And Berkeley Born is one who did see it coming. The wonderful book, The Big Short, by Michael
Lewis.
Lewis, thank you.
Yes.
I recommend this book very highly. Lewis found half a dozen guys who saw the crash coming, made huge investments based on the idea that the crash was coming, and reaped billions in rewards for doing so.
Right.
But they undermine the Greenspan argument, but so does Berkeley Born, because she, as chairman of the Commodity Futures Trading Commission under Clinton, made a proposal endorsed by many professors of finance at the business schools of America. It's time to regulate these derivatives. They're very dangerous, potentially, to the financial system. This was about the time that Warren Buffett wrote an op-ed in the New York Times, which called derivatives financial weapons of mass destruction. And she said, let's just make everybody register. We don't have to close off this market. Let's just try to get it into the public domain, get people to show what they're doing and show their cards. Everybody in Washington, Arthur Levitt, the head of the SEC at the time, Larry Summers, the Secretary of Treasury, particularly Greenspan, Chairman of the Federal Reserve, went to Bill Clinton at a famous meeting and said, no, don't do this. This is a mistake. We shouldn't touch this. It works fine. It's a great provider of lubricant to the financial system. Leave it alone. But, they were just all dead wrong.
First of all, on the Great Depression, Milton Friedman's view was that the cause was the failure of the Federal Reserve to avoid excessively tight monetary policy in the early 30s. That was Friedman and Schwartz's famous book. And with that lesson in mind, the Federal Reserve has reacted very aggressively to cut interest rates in this current crisis. And moreover, we've also tried to avoid the collapse of the banking system, which was another reason for the Depression in the 1930s. On prices of housing and the like, we're not trying to prop up the price of housing. What we're trying to do is get the credit markets working again so that the free market can begin to function in a normal way instead of in this seized up way in which it's currently acting. And finally, on price fixing of so-called toxic or legacy assets, the plan that Secretary Geithner described this morning would have as an important component private asset managers making purchases based on their own profit maximizing analysis. So that would be true market prices that would free up what is now a frozen market and get transactions flowing again, and should restore real price discovery to those markets.
When you're ready to make a difference in the world, one law school can make a difference for you. The Massachusetts School of Law is where you learn to become a lawyer. As the most affordable law school in New England, you'll graduate with the most professional skills and the least amount of debt. Our small classes ensure a rich learning experience and a campus environment so special, our students don't want to leave. The Massachusetts School of Law. We're ready to make a difference for you. Visit us today at mslaw.edu.
After the census in the year 2000, the United States Bureau of the Census reported the astonishing statistic that 31% of American babies are now being born to unmarried mothers. Even more astonishing is the fact that many of these mothers are living in long-term, loving relationships with men whom they nevertheless choose not to marry. This is a show about unmarried cohabitation. Marriage brings you legal benefits which cohabitants don't get. So what are these people missing out on by cohabiting without marriage? First of all, divorce. It may seem paradoxical to describe divorce as one of the benefits of marriage, but divorce is just the outward manifestation of the underlying rule that you can't walk away from a marriage as you can from a cohabitant relationship. To break up a marriage requires a supervised process called divorce in which the needs of both parties in the future are taken into account. Cohabitant relationships can break up with no responsibility on the part of either partner for the other in the future. Second, next of kin status. When you marry, you become your spouse's next of kin. This can be important, especially at the hospital. Next of kin can consent to medical procedures and emergencies, can authorize autopsies, consent to organ transplantations, may have special visiting rights, and after death can direct the disposition of the remains of the deceased spouse. If, for example, there's a question whether there's to be a religious funeral or not, the next of kin has the say. A cohabitant is just a friend who does not have those legal rights. Next, spousal testimonial privileges. In all American states, there are two rules of evidence that protect spouses from having to testify against the other spouse in a criminal proceeding, except one involving violence towards the spouse, and the second is one which protects spouses against having to reveal confidential communications between a husband and wife. Cohabitants have no such rights. Very important are inheritance rights. In all American states, the surviving spouse has a right to inherit from the deceased spouse's estate, and that's true no matter what he put in his will. And I use the word he advisedly because in America, women tend to outlive their husbands, and husbands tend to have most of the money. So in practice, this becomes, in most cases, the right of a widow not to be rendered penniless in her old age because she will be able to inherit a specified amount from the estate of her deceased husband. And again, no matter what he wanted, she has that right. Cohabitants don't have it. A deceased cohabitant can leave the other cohabitant without a penny, and there is no protection comparable to that which is available to married couples. Survivorship rights. You can't be somebody's widow if you were never his wife. And Social Security benefits and insurance payments and so forth may depend upon the status of marriage at the time of death. Again, married people will have these rights, cohabitants will not. Finally, and this may be most familiar, there's the joint tax return. Add up your taxes if paying separately, add up your taxes if paying jointly, and see which is lower and pay the lower amount. It's perfectly legal, and only married couples can do it. If you ask cohabitants why they don't marry, typically they will say, well, we love each other and we take care of each other, and that piece of paper won't make any difference. That is profoundly wrong. That piece of paper does make a big difference.
One of the ways that Dodd managed to get the bill through the Senate is that he was very solicitous. I got the impression far more solicitous than is normal of the Republicans. You know, same thing, Republicans, Democrats. And some of them were at sometimes very helpful to him, but and he accepted a lot of their amendments. And in the end, only 4 Republicans voted for Dodd's bill. I mean, what gives? As
3, actually.
3?
Dodd had an image, not an image, a desire to make the Senate work the way he remembered it working from the good old days.
Yeah.
Of the 80s even, he considered the good old days.
Were there good old days?
Well, you know, there's always a rosy rear view mirror, as somebody said. But yes, there were. You know, Dodd had a very good legislative record. Dodd had a lot of accomplishments. If you or I had done what Dodd had done, we'd feel pretty good about ourselves. Family medical leave is the leading example. Millions and millions of Americans have benefited from Chris Dodd's Family Medical Leave Act, which he took him years and years of patient effort to get through, but it had a Republican co-sponsor. Every big bill, he pointed out to me again and again, every big bill I've ever passed had a Republican co-sponsor. And he remembered them. He'd say it was Joe Blow on this one, Frank on this one. And he was determined this time to try to do the same. His first target was Shelby, the ranking Republican, who had preceded him as chairman of the committee in the last 4 years of Republican control, and then became the ranking Republican in 07 after the Democrats won control.
Just for the audience, the ranking member simply means the highest ranking guy on the others.
On the other party, exactly. Thank you. I tried very hard in the book to avoid the jargon of Washington.
Yeah, well, I mean,
and
that's
you just caught me. I mean, that's good. So, Shelby is an old-fashioned Southern Powell, big guy, football player, nice guy, smart guy too, smart, very bright, but had a real chink in his armor. Why? Because for the first 20, 30 years of his career, he was a Democrat. He switched to the Republicans in the Reagan years, and later, in the 90s, after the Republicans won control of Congress, and he wanted to be a subcommittee chairman, they induced him to switch. It wasn't a big betrayal of principle in his part. He was a very conservative Southern Democrat.
Sure.
But it made him an object of suspicion, particularly among the young Republican firebrands who didn't know American history very well and didn't understand what Shelby represented very well, in my opinion, and were always eyed him with great caution. And so Dodd spent a year cultivating Shelby. The Dodds and the Shelbys went out to dinner together in Washington repeatedly, which is very unusual in modern Washington, that kind of cross-party socializing. Used to be typical, now rare, sad.
And it was regarded as a terrific lubricant.
Yes, of course, and it was. So Shelby is, I know because I'm interviewing him, he's cooperating with me from the beginning, and I'm going to see him every few weeks, a month or two, and he's telling me, I want to do this, I want a bill, I think we can do this, it's important. He could never get there. Why? Because Mitch McConnell kept telling him, no, you can't go there, don't go there, don't do that. And he had to curry favor with McConnell and the other Republicans to fulfill his lifelong ambition and a career-long ambition to become the senior Republican on the Senate Appropriations Committee. Shelby is an old-school pal who loves spending the government's money. Here's my favorite fact about Shelby. There's a Richard and Annette Shelby Research Center. Annette is his wife, a professor, interesting, smart woman. At every major university in Alabama, 5 of them, they all have a Shelby Center. Every one an earmark appropriation, which he got through as a member of the Appropriations Committee. It's what he loves to do, to spread the money.
He doesn't have any ego, does he?
No. Alabama is one of those successful southern states that gets about twice as many federal dollars as it sends to Washington in tax revenue. There are many such. Massachusetts, New York, Connecticut all get less back than they send.
And all the while railing about the federal government.
Of course, of course. So Shelby, just couldn't get to the finish line.
Yeah.
This did not deter Dodd, and Dodd kept cultivating him, And in the end, in fact, they made one deal on the eve of the bill coming to the floor, which Dodd thought was crucial to the success of the bill. It was a Dodd-Shelby deal. But there were 3 Republicans in the Senate, all from New England, all old-fashioned, almost extinct, moderate Republicans.
Two female senators
so
from Maine.
I know her very well. Come to me a sec. And your guy Scott Brown from Massachusetts, who were all inclined to be in favor of a tougher bill, but were all nervously dancing through the Republican caucus potholes.
What do they have to fear from their own party if they got them angry at them?
Same thing Shelby did. It was losing their chance to be a chairman or a ranking member, losing their influence.
I see. So it's all a question of intra-house ambition.
Yeah.
Something like that.
Yes, it is, largely.
Yeah.
So Dodd decided that he would check in with all 3 of them in the last couple of months of the debate on a daily basis. He told his staff to check in with their staffs, anything they can do, and please try to help them every way you can, and so on. He gave them all amendments that were embraced. It was very clever, and in the end, they all 3 came through for him.
Chairman, 14 years ago, I started on this journey of family and medical leave, and I'd be very remiss, particularly in this body, if I failed to mention the name of Patricia Schroeder, who was really the person who originated the idea. That day of the bill signing in February of 1993, she was not included to stand on the podium at the Rose Garden at the White House. And I've always regretted deeply, because she should have been there. She was really the person who initiated the idea. I authored the bill in the United States Senate, and as you pointed out, it took 3 presidents, 7 years, and 2 vetoes to end up with the bill. And I should point out that it never would have happened without the support of Arlen Specter, of my good friends as well, Kit Bond of Missouri, Dan Coates of Indiana. Senator Kennedy was tremendously influential. It was a bipartisan effort. It took a long time, but we ended up adopting that legislation. And today, 14 years later, 50 million Americans have been able to take advantage of this protection of caring for a sick loved one, recover from an illness, or welcome a new child into the family, among other things. And after many minutes of time, we see that the debate is no longer about whether Americans have a right to its protections, but rather about how best to expand those rights.
Massachusetts School of Law. Legal education that is practical, accessible, affordable, and enjoyable. Offering flexible day and evening classes, full or part-time studies, where candidates are assessed not on the LSAT, but their academic and other accomplishments, providing more professional skills training than any other law school in New England. Massachusetts School of Law. Visit us at mslaw.edu, training students to become successful lawyers and advocates, not just legal scholars.
Most of us know the great joy and happiness that animals bring to our lives. My dogs, Whitey and Winnie, always bring a smile to my face. As a professor in our Animal Law Initiative, I am often asked about liability if a dog bites, and whether it's really true that every dog gets 1 bite free, that is, without owner liability. In Massachusetts, the owner or keeper of a dog is strictly liable for a dog bite, unless the victim was trespassing, teasing, tormenting, or abusing the dog, or committing some other civil wrong. Minors under the age of 7 are presumed not to be committing trespass, teasing, tormenting, or abusing, or committing some other tort. So the burden then would be upon the dog owner if the child is under the age of 7. Thus, it's important to keep your dog safe of others, especially young children. As the guardian of a dog, it is expected that you properly secure your dog so the dog cannot injure. Make certain you do not entrust your dog with someone unfit to properly restrain the dog if necessary, because Massachusetts imposes strict liability. There is no requirement that the owner be negligent in proving liability. Other states may base liability on a common law theory of negligence, which requires a showing that the dog owner or guardian owed a legal duty to the injured party and that that duty was breached. In these jurisdictions, the court may consider whether the guardian knew of the animal's propensity to bite. The law recognizes most dogs are friendly, so there is no imposition of liability unless the pet's guardian had notice of the likelihood of the dog biting. Irrespective of whether you are in a strict liability state like Massachusetts or not, if a dog is tormented, incited, provoked, those actions will be a defense to owner liability, either reducing or barring the plaintiff's claim. Provoking, annoying, or harming a dog is not acceptable behavior, and our law generally recognizes this, except if a child is very young and the child may then lack the requisite intent. Also, just about all states have dangerous or vicious dog laws, making owners of such dogs strictly liable. So as the saying goes, quote, breed not a savage dog, nor permit a loose stairway.
In the end, our financial system only works. Our market is only free when there are clear rules and basic safeguards that prevent abuse, that check excess, that ensure that it is more profitable to play by the rules than to game the system. And that's what these reforms are designed to achieve. No more, no less. Because that's how we will ensure that our economy works for consumers, that it works for investors, that it works for financial institutions, that it works for all of us. This is the central lesson not only of this crisis, but of our history. Ultimately, there's no dividing line between Main Street and Wall Street. We rise or fall together as one nation. So these reforms will help lift our economy and lead all of us to a stronger, more prosperous future.
Back in the day when I was in Washington, congressional staffers numbered maybe 3,000 or 4,000. Now they number about 10,000 or something like that.
Yes, it grew a lot beginning in the late 70s. It stopped growing, and indeed, Newt Gingrich cut it back some in the 90s. But it's a huge army. Although arguably, you could smart members say, I wish I had more people because I'm all these other committees, I can't keep up with all the issues. I could use 2 or 3 more people to help me do it.
There's a lot in the book that explains the crucial role of honesty with each other, not only among the legislators, but among the staffs. Yes. And you point out that a couple of these Republican staff members were simply not to be trusted. They would go back on their word.
Well, and one Democratic one.
One Democratic one.
One important one, who worked for Blanche Lincoln, the senator from Arkansas.
Yes, yes.
A real scheming guy who was dishonest with his colleagues, and they detested him.
Yeah.
And he did a lot of damage too. He weakened the bill, interestingly, because they couldn't. It's a long, complicated story. It's in the book, but he stuck things in that shouldn't be in the bill.
Yeah. Explain just a little bit of, if you would, about the conference committee. What conference committees are, what they do, what they used to do, what they do now, what happened in the Financial Regulatory Reform Bill conference.
This is an important change that many people are not aware of. For most of the history of the modern Congress, the 20th century certainly, the standard procedure was the Senate passes a version of a bill, the House passes its version of the same legislation. They're not identical ever. They always have little differences or big differences. And they both appoint conferees, members who had worked on the bill in both houses, to come together in a conference committee, hash out the differences, and produce from the 2 bills one version that could then be voted on by both houses and, if passed, signed by the president.
Chairman, my amendment would be in reference to what I believe is item number 32 in the Senate response, which was to reject the House position. I believe that for a long time now, we in this country have recognized that what are called non-accelerated filers, that's small businesses with a market capitalization of $75 million or less, are unduly burdened by the Sarbanes-Oxley Section 404B requirements. And in response to that, the SEC for several years now has exempted them itself.
This graph here indicates that 53% of smaller businesses would be exempt from this, 47 would comply, and as you point out, there has been an effort. Back in 2003, after the, in fact, I think in this very room, was the conference between Paul Sarbanes and Mike Oxley on the adoption of the Sarbanes-Oxley legislation. In 2003, we all heard from the smaller public companies about the problems of compliance with the audit requirements. Since that time, I'm led to believe, based on inquiries we've made, that a lot of those concerns have been alleviated, but nonetheless, I realize there's still some worried about the cost of all of this. I pointed out earlier some of the problems exist in smaller companies, and where investors are investing in smaller companies, there's no less risk of losing their investments. So I still think there's a value of it. I appreciate what went on in the House and the White House's support of the House provisions, and as well as the concerns being expressed by the small business community. So I would still urge us to stick with the House Senate position, but anyone else want to be heard on this?
But I believe that clearly, since we have not been requiring the compliance of these companies by SEC rule for several years, and it's very clear that there has not been a negative impact from that.
For 25 years, the Massachusetts School of Law has been training great lawyers and building great relationships.
Joining MSL was more than just making friends. It was becoming a part of a family, which makes it very difficult to leave.
I don't want to leave MSL. We didn't want to leave MSL ever! Best decision ever! We love MSL and we don't want to leave.
The Massachusetts School of Law. Great lawyers, better people. Come join our family. Visit us today at mslaw.edu.
In the Gingrich era, in the 90s, beginning in 95, the conference committee went out of fashion. It became very rare. Gingrich much preferred to keep control of the process and to have a leadership-to-leadership negotiation, often excluding the members who had done the most work on the bill under consideration. And they'd work out a deal, leadership-to-leadership, create this new bill with the help of their staffs.
I mean, that's an excessive use of power.
I think it is, but it became commonplace. And the Democrats sadly embraced it when they came in. So in the first Democratic Congress, 07 and 08, there was too much of this still going on. Barney Frank, to his credit, said from the beginning, when we pass these bills, we're going to have an old-fashioned conference committee. But it's going to be new-fashioned in one important respect. It's going to be in the open. We're going to invite the TV cameras to come and the reporters to come. We're going to have an open conference. This made everybody nervous, including his own staff. One of his key guys, Dave Smith, chief economist of the House Banking Committee, said to me while this was going on, I don't want a conference. Conferences are dangerous. Once you get into a conference, anything can happen, which is literally true because you got a majority of the conferees can introduce some new element to the bill. They can make some big change to it. It's not, nobody's in control. But Barney was going to insist on the conference, and he did.
In effect, the conferees can de facto write a new bill.
They can.
Yeah.
There's no legal, it has to get passed again, so it's not, they can put it
when
into
these things
effect.
come out of conference,
They can
either
be quite
pass them or
different.
they're dead in the water, right?
Exactly.
Yeah.
And they can be quite different than what went into conference.
Yeah.
This was not the case this time. The two bills were quite similar, not least because both House and Senate worked off an Obama administration draft, which was the framework for both bills.
I do think that speed of response is very important. As you all experience firsthand politically, it's not easy to bring the public along to trying to address problems in the banking system. And in Japan, the political resistance was one of the reasons why it took a very long time to address the problem. American people have complained a lot, and I don't blame them. But on the other hand, I think people understand that something needs to be done, and these steps that are being taken, as distasteful as they are in some cases, are essential. And I think it speaks well of the Congress that you did act to take these steps, and that we are moving in a reasonably expeditious way, given the speed of events and all that's happened, to begin to tackle our problems. And we're much better off addressing them quickly than letting them fester.
When you're ready to make a difference in the world, one law school can make a difference for you. The Massachusetts School of Law is where you learn to become a lawyer. As the most affordable law school in New England, you'll graduate with the most professional skills and the least amount of debt. Our small classes ensure a rich learning experience and a campus environment so special, our students don't want to leave. The Massachusetts School of Law. We're ready to make a difference for you. Visit us today at mslaw.edu.
Because of the highly publicized Karen Quinlan case in New Jersey in 1975, the public and lawmakers have paid more attention to whether a person may refuse life-prolonging medical treatment when the person is suffering from a terminal injury or illness without hope of recovery. Lawmakers have responded to public concern by enacting statutes which permit persons to make so-called living wills. A living will is a document by which a person makes known his or her desire and direction that medical professionals do not use measures to prolong his or her life in circumstances where they cannot hope to recover. Federal courts and most state courts have interpreted their constitutions to recognize a constitutional right of privacy, to be free from unwarranted governmental intrusion into matters affecting a person's fundamental rights. Courts have extended this right of privacy, even in the absence of statute, to allow a competent adult to refuse medical treatment that may prolong his or her life. Specifically, the Florida Supreme Court has ruled, in the absence of any statutory authorization, that the relatives of an incompetent and terminally ill patient could halt extraordinary medical treatment even without first getting court approval. The court gave considerable weight to the patient's, quote, mercy will and last testament, unquote, in which he expressed a desire not to be kept alive on a respirator or other life support equipment. The patient had executed this statement almost 6 years before he entered the hospital, but while he was still competent. The Karen Quinlan case stirred the concerns and imaginations of the public. Quinlan was a 21-year-old woman who had stopped breathing for 2 15-minute periods, apparently because of drug and/or alcohol abuse. She fell into a deep coma and was attached to a medical apparatus which maintained her bodily functions and kept her alive in a New Jersey hospital. It was clear that although technically alive and not brain dead, the evidence suggested that she was in a persistent vegetative state and would never again function as a thinking human being. It was also clear that if her respirator were removed, she would die soon thereafter. Her father, a devout Catholic, sought guidance from the church. The church advised him that discontinuing the respirator would be a, quote, morally correct decision. He then sought to be appointed guardian of his daughter so he could order the hospital to terminate use of the respirator. Although the state of New Jersey opposed his request and the lower courts had ruled against him, the New Jersey Supreme Court reversed the lower courts and upheld Mr. Quinlan's right to act on behalf of his daughter and remove the life support. The first legislation passed was in California, which enacted the California Natural Death Act in 1976. Since that landmark California law, states have passed laws on the subject. Because of the significant variation in these laws, the National Conference of Commissioners on Uniform State Laws has passed a uniform act entitled the, quote, Rights of the Terminally Ill Act, end quote. The act contains a suggested declaration directing a doctor to withhold or withdraw life-sustaining procedures if a person is, quote, in an incurable and irreversible condition that will result in death within a relatively short time, end quote. The act specifically provides that it should not be construed to condone, authorize, or approve mercy killing or euthanasia. This latter provision is designed to counter the objections of many who argue that proponents of living wills advocate mercy killing or euthanasia. So, You need a living will if you want to be the one who controls decisions about ending your life if you are ever unfortunate enough to wind up in a terminally ill state. While your state might have provisions for ending life support even in the absence of a living will, you should strongly consider drafting one or having a lawyer draft one for you to ensure your ability to control these decisions. Thank you very much.
You take the position, which I wouldn't say surprised me, but one is not used to seeing it from people of, now let's be candid here, national journalistic prominence. You don't normally see that from people. You say, our American legislature is broken, period. Doesn't work. Why do you feel that way?
Do I have to answer that question? Don't you feel that way?
Yes, I do, but what do I know?
Well, you know the results. You see it going on all the time. I mean, think about just the last 20 years. Rising income inequality, a huge fall off in the American educational system compared to other countries. Global warming, an enormous environmental catastrophe going on around us all the time. Healthcare, which for the longest time we had the worst healthcare system in terms of coverage of any advanced democracy, any industrial democracy. On and on. A huge list of unaddressed or poorly addressed big national and international problems because our Congress can't do anything. It's fascinating and troubling, but that's the basis of my judgment, and we've been paralyzed for a long time.
When you say Congress,
and it gets worse and worse and worse.
And that's because people just can't agree, and there's too much partisanship. Are these the fundaments of it?
Yes, we have something now completely new to me since 2010. The House Republican caucus is now controlled by people who actually don't believe in government, who actually feel that the country would be better off with a much smaller government, much less intrusive government, etc. A legitimate philosophical position, but one which, when held by the people who are responsible for government, has very risky consequences, very dicey consequences. And this rise of an ideologically fervid anti-government faction into a position of dominance in the House now. They dominate the House. This is a huge departure. And because they measure their own worth, these people, by the degree to which they can uphold and advance their own very extreme ideological agenda, they are not interested in the old-fashioned methods of splitting the difference, finding a common ground, etc.
Does this result in part, Bob, from the fact that House districts have become single-party districts?
Sure, that's part of it.
That's part of it? What else is part of it?
Well, let's think of what are the factors. One is the collapse of the moderate wing of the Republican Party, which used to have a very strong foothold in Massachusetts, Connecticut, New York, Pennsylvania, Illinois, etc.
Northeast Republicans.
And Midwest, both. And they were largely wiped out. So the Republican Party has become, in the last generation, a party dominated by the South and by religious conservatives. The polling figures are quite startling. More than half self-identifying Republicans are also self-identifying evangelical Christians. This is not a cross-section of America. It is a very specific, very narrow faction, relatively speaking. At the same time, the new America, the diverse America, the black and brown America that has become so significant in national politics has become almost entirely Democratic, overwhelmingly. So there are a lot of factors that are dividing the society that are also dividing the Congress. But the redistricting is important, and it's more than just gerrymandering, which is the deliberate drawing of boundaries favorable to the party who gets to draw the boundaries, which has been going on since Elbridge Gerry of Massachusetts first did it in the 19th century. But it's also a function of the fact that Americans are sorting themselves out by political and religious inclination. So the young people moving to New York City or Washington, D.C. or San Francisco or Boston in droves tend to be much more liberal, much more tolerant, much more relaxed about homosexuality and gay marriage and things like that.
Is this one of those situations? I think Robert Maynard Hutchins once said something like this. I may have even been there. Is, you just got to wait for people to die off. In other words,
well, but there are a lot of young conservatives too.
Pardon me?
There are a lot of young conservatives in the South.
So it's not just a matter of waiting for
not
people to
only,
die off.
Yeah. But there is. It's very interesting. In general, it is that, because if you look at the polling now, the under 35s are literally twice as liberal as the over 50s in American life. We're seeing the rise of a millennial generation that is just much more liberal than its parents and grandparents. So it'll be different.
Do you think that the American public is not really aware of a lot of this, because if it were aware of it, it wouldn't stand for it?
I do. I think I'm a political guy. I grew up in Washington. I've devoted my life to this stuff. I am exasperated and frustrated by my countrymen, God bless them, who refuse to take politics seriously, who refuse, from my perspective, to exercise the rights of citizens to be engaged, to influence what's going on, and so on. We are so distracted now by amusing ourselves and by the struggle for daily existence, which has gotten harder, not easier, at every level except the top level in American life. Stunning statistic in today's New York Times that the average family income in the United States is exactly the same today as it was in 1988, as after adjusting for inflation. As the author of this piece said, what happened to progress? We're stopped making it.
Yeah.
So anyway, this is part of the deal. But in any case, we've always had, de Tocqueville wrote about it, an apolitical society, a society in which politicians were regarded suspiciously and people thought politics was somehow corrupting and corrupted. This is part of the American tradition, and not necessarily a bad part. But it's been taken to ridiculous extremes now, and we just don't have enough citizen engagement. And the rise of money in politics, the takeover of our politics by big money, compounded by the Supreme Court in the Citizens United decision. It's a bad thing. And most people who I encounter and question about this don't really understand that we've undergone a profound qualitative change that's really different than just 20, 30 years ago. I think people will come to their senses. I think there will be some discontinuity in the next years, next 5, 10 years.
It's a curious thing, Bob. When you see things like this, you can't take politics seriously, and as long as you don't take politics seriously, you're going to see things like this.
Exactly right.
Yeah. Thank you very much for coming up.
Thank you. It was very good.
Well, you write great books.
Thanks.
So we're pleased that you come. And to the audience, thank you for being with us, and be with us again next time.